Much has been said, my lords, by the learned councils who have already made submissions. But speaking for myself, we belong to that state and we have lived through this 370. We have been brought up in this 370. It's a part of our mindset, this 370. And we were really shocked when the notification of 272 was issued on 5th of August 2019. It was unexpected and one could never imagine that this could so suddenly happen. Because in order to understand this 370, there are a few approaches to its understanding. One would be, in the first instance, if the Maharaja way back, perhaps before the birth of all of us, when he entered into Instrument of Accession only, why didn't he enter also into merger agreement at that point of time? All this debate would not have been here. It could have been straightway a part of the Union of India. He did not do that. So that's a question which needs to be inquired into. Why didn't he do that? That's number one. And number two, if he only entered into Instrument of Accession, what is it that he parted with as a sovereign king? And what is it that he retained with himself? My understanding of the case is this, and perhaps many things will become clearer, that the Union of India by itself was one authority. This Maharaja of a state, of a very large state among the native states, was another authority. When the Indian Independence Act was passed, Government of India Act 35 was applicable. They became all independent sovereign states. All these native states, including the state of Jammu and Kashmir. When we proceed on that premises that they became independent sovereign states, then comes the question of accession to either of the dominions. All other states in India, native states, whether they were as small as 1 kilometer or they were big states, either they merged with themselves, but ultimately all of them merged with Union of India. And this merger word is extremely important, and I think that's the basis of this 370. He did not enter this merger agreement at all. He entered into standstill agreement only with Government of Pakistan. The Government of India did not agree to enter into the standstill agreement. This was the situation in 1900, prior to 1947. Now, because of the extraordinary situation which arose in the state of Jammu and Kashmir, having no choice in the matter, he enters into this Instrument of Accession on 26th of October 1947. What does he do under this? He, in simple language, he says that the Union of India will have the power to make law for defense, communication, and foreign affairs. He doesn't give any other power to them. Only these three subjects. But for remaining subjects, I mean, running a country, you need so many laws. For remaining subjects, he retained all the powers with him under clause 8 of this Instrument of Accession. Now, in the absence of merger agreement, obviously these laws, this power to make the law, and where he had this legislative autonomy, would not have been transferred in the absence of such an agreement. This is the situation. He left. Thereafter, he asked his son to take over. His son takes over Dr. Karan Singh. He also does not enter into any kind of merger agreement or supplementary agreements. This is the situation on the one side. On the other side of the picture is that so far as the Government of India is concerned, it was already in the process of making the constitution. That was not meant for the state of Jammu and Kashmir, but for the entire country. All native states have merged and ultimately become part of the Union of India. All those native states. There were three only left. That was Junagadh, that was Hyderabad, and state of Jammu and Kashmir. So far as Junagadh is concerned, there the king belonged to a certain sect. He wanted to accede to Pakistan, but the people did not want it. So therefore, they ultimately held a referendum in Junagadh on 20th of February 1948, and the people overwhelmingly voted to be a part of India. So far as Hyderabad is concerned, the situation is altogether different. Ultimately, Hyderabad also merged with India. But state of Jammu and Kashmir, out of these three, did not enter any kind of an agreement. It remained a separate state, but with only power with the union on these three subjects which I mentioned. But when this Constitution of India was being made, a significant development takes place at that point of time, which had its impact on this relationship, which was normally between a native state and the Union of India. That is, the situation arose in the state of Jammu and Kashmir such that the matter had to go outside the country to United Nations. When it went to the United Nations, as many as 5 or 6 resolutions were passed there. They also said that this instrument of accession should be put to the people's ratification. This is on, not only they said it there, on 27th of October letter, which has already been read to your lordships, it also said that as and when the situation in Jammu and Kashmir becomes normal, this particular instrument accession will be put to the ratification of the people. It does not take place. The UN security resolutions do not take place. But yet, the Constitution of India was being made, and there was only instrument of accession. These are extremely 3 factors which resulted in making this Article 370. Now,
what are the three factors? What are the 3 factors? We can just itemize them.
No merger agreement?
Just one second.
Yes. October 1947 letter of the Governor General. And 3 UN resolutions.
Fisher, who are you appearing for? We'll just for matter of record.
Appearing?
Which petition are you appearing?
Bar Association.
Bar Association.
Yeah.
Which is that writ petition number? 1268.
I may be excused for because my files are not that organized as I see my senior friends who are not much used to this.
You possibly don't need.
System. We still have physical files with us. I may be excused for that.
But I don't think you need the files.
We also have my AR will give a lot of the number.
1268. 1268.
21, yeah.
This is the Bar Association.
So the third factor was UN resolution. These were the 3 factors. Now this is the situation preceding making of this Article 370. Now when it goes to the Constituent Assembly, at that point of time, the representatives of Jammu and Kashmir were not there in the Constituent Assembly. They become members in June 1949 after amendment is carried out in the procedures of becoming a member of the Constituent Assembly. So we have the representatives from Jammu and Kashmir in June 1949. By that time, almost entire Constitution of India had been adopted. Because finally the Constitution is adopted on 26 November 1949. So hardly few months are left when the representatives of Jammu and Kashmir become members of the Constituent Assembly. Then in October 1949, this article, which was originally 306A, is debated. In that debate, which references can be made, I'm just giving the narrative to the whole case, but I'm standing here for. There, the mention expressly is made that look here, the position of the Jammu and Kashmir is uncertain. Why is it uncertain? It was uncertain because number 1 of the Governor General's letter of 27 for 1947 and the government of India being entangled, that's the exact word used in the Constitutional Assembly debates, being entangled before United Nations. So one doesn't know what happens, whether this is going to stay, this is not going to stay, whether it should merge with India, it should not merge with India. This is the situation existing. And it is in this background that somebody had to think of. What do we do with the state? It had entered into Instrument of Accession. It was one of the federating states, if I put it that way. But this was not fully a federating state, like any other state, because of the absence of merger agreement. So some way had to be found. Madhur's observation was correct, that after this Instrument of Accession is executing and 370A is made. If we look at 370A, it seems to absorb, subsume within itself that power which the king had, the Maharaja had. What is the power which he had retained with himself? He had retained the entire residuary, if I say so, sovereignty with him. What was the concept of sovereignty? The power to make the law. What does it mean, sovereignty? That is the whole thing. The power to make the law. He had retained that with himself. I'll make the law, except on these three subjects. Law related to defense, law related to foreign affairs, law relating to communications. All other powers I will retain. Then the question further arose, now what happens to Jammu and Kashmir? We need a constitution. How do we run the state? We earlier had a constitution of the Maharaja, that's of 1996. But the structure of the constitution was different. There was Praja, there was the king. He had the exclusive power under section 5 and 6 of that act. He could do anything. But since the democracy had set in, so therefore that particular constitution had become inappropriate. That's why Dr. Karan Singh in his communication says, because of the change of situation, we need a new constitution. Why the need for new constitution? Because the state had retained with itself the entire powers. So here essentially also we are concerned with the right of the state of Jammu and Kashmir. It's not the right of an individual. It is not simply the right of the people of the state. It's the right of the state which is in question. That what kind of right is this state possessed under the Instrument of Accession? So, sir, this Article 370 is based, according to my perception, it is based, number one, that it subsumes the sovereignty which was retained by Maharaja, number one. And number two, at the same time, its finality could not be determined of the state itself, not of Article 370, but of the state itself, because of the dependency of the matters which I indicated.
Zafar Shah, what is the second point? The first one you said is that Article 370 subsumes the sovereignty which was retained by the Maharaja.
And number two, I said.
So when you say subsumes the sovereignty, are you therefore suggesting that sovereignty still continued to reside in the state?
370 itself, but which kind of sovereignty?
370. Sorry, yes.
Power to make laws, sovereignty or power to make law. There could be semi-sovereignty, quasi-sovereignty, there are different types of sovereignties. I'm here focusing on the power to make laws was retained. In terms of this 370.
Would that really be a correct reading once accession takes place? And what happens is that there are certain fetters, there are certain reservations which are retained in the Instrument of Accession, that he unconditionally recognizes the sovereignty of India, but he retains certain exceptions. He carves out certain areas which he retains to himself. He says, I am surrendering the power to make laws only in reference to defense, foreign affairs, and communication. Broadly, the three heads.
I give it to you.
That's right.
He donates the power.
But what does accession really mean? Accession means that, Jammu and Kashmir becomes a complete and intrinsic part of India. There would be no going back on that, isn't it?
No, one view would be that whether in terms of territory it is transferred. So what do we mean by accession, the word? One would be the territory itself is transferred to India. Means that de facto, the union government is in possession of the state of Jammu and Kashmir, but de jure, the sovereignty is not transferred to the Union of India.
Or would it be the correct reading would be that for that matter, say, take any other state. Take the state of Uttar Pradesh, Maharashtra,
Yes.
Tamil Nadu.
Yes.
There are certain fetters even on the power of Parliament to enact laws. Parliament cannot enact laws at all with respect to List 2. Parliament can enact laws only on List 1 and List 3. In relation to, say, NCT of Delhi, which came in 1992, Parliament can enact laws on List 1, 2, and 3, but the state legislature of Delhi cannot enact laws in under list 2 on entries 1, 2, and 18. So there are different models which the constitution is following.
Possible, yes.
What seems to happen with the instrument of accession is that sovereignty is transferred and recognized in the dominion of India. But the power of legislation, because legislation is an incident of sovereignty, but legislation is not the entirety of sovereignty. Legislation is one aspect of sovereignty. On that aspect, namely legislation, the power is not entirely recognized as inhering in the Parliament of India, which it otherwise has in relation to the union list and the concurrent list. But notwithstanding this, the instrument of accession says that unconditionally you are acceding to the dominion of India.
No.
Just one. Paragraph 4 of the letter says, I hereby declare that I accede to the dominion of India.
Accede. C8.
And then he says that if an agreement on the assurance that if an agreement is made with the Governor General and ruler of the state, whereby any functions in relation to administration of any law so and so shall be exercised. But 5 then goes on to say that the terms of this instrument of accession shall not be varied by any amendment of an act or Indian Independence Act unless such amendment is accepted by instrument supplementary to this instrument.
Very right.
Now what happens is when in the constitution, one is accepting that you are now merging with India, except these powers will be, or as pointed out, these legislative powers or these administrative powers will be still vested with the ruler. And it is subject to the condition that by supplementary instrument that can be further diluted. Not the power taken already, the sovereignty which we have merger which has taken place, but with regard to that. Then when you become a members of the Constituent Assembly, and then you decide how it goes about with passage of time, you participate in the minutes. Then there's a Constituent Assembly also for the state of J&K. Now, will it be correct to then go back so much in point of time?
First of all, my lords, what you also read, kindly see clause 8 also, which gives to the Maharaja, he retains all the powers with himself, except in respect of these 3 subjects. He retains all the powers. Now, when he retains all these powers, should I read that to your lordships?
Yeah, I've got it with you.
Your lordship. When he retains all these powers with himself, what is to be done with this? You accede, whatever the meaning of that accession may be, let's take it like that. But is it not also an act of state between the Union of India and the state of Jammu and Kashmir? This instrument of accession is an act of state. The 2 states say, 2 independent states say, 2 sovereign free states say, look here, I agree to be with you. I will shake hands with you, but I will not embrace you, if I put it that way. Metaphorically, if I put it, I'll shake hands with you, but I will not embrace you. Done by the king. Why king did that? History tells us that he wanted to retain the Jammu and Kashmir as an independent country. That's the whole basis of it. Otherwise, nothing prevented him, like any other native prince, to merge with India, to totally erase itself of its statehood. What is it that if you enter only into instrument of accession, do you still retain sovereignty with you? We have the judgment of this court. As I unfold my submissions, I'll show the judgment. You retain the sovereignty. You don't surrender the sovereignty merely by instrument of accession. Yeah, of course, you do that. Of course, you do that subject to 2 conditions. 1, your standstill agreement, and number 2, you have the merger agreement. And both are provided for in the white paper of states issued by the government of India. He doesn't do that. See this problem of ours, problem of the state of Jammu and Kashmir. When he doesn't do that, and as a 2 separate states, he says, I agree with you, but I'm going to run my own state myself. You take care of my defense. You take care of my foreign affairs. You take care of my communication. The government says, okay, we'll take care of these 3 things. Because situation had emerged in the state where the help was needed from India and the Indian army landed there. So he says, look here, you take these 3, but rest I run my government myself. That was the whole intention. original intention of the Maharaja when he executed Instrument of Accession. Now, when subsequently few changes take place, he leaves the state, his son also does not do that, but yet the constitution is being made. What do you do with this state? I have not merged, so you don't treat me as one of the states of India. But yet, I am a part of the federation. I am a federating unit. Therefore, this special relationship. Therefore, the genesis of Article 370, this is the special relationship between the state of Jammu and Kashmir and Union of India. The extent and other things, we'll debate that as well. But this is the special relationship between the state of Jammu and Kashmir and the Union of India. What should the Constitution of India do with such kind of a state, which has not merged, which has yet asked me to make laws for it, and yet remains separate? Therefore, 370 makes mention significantly of Instrument of Accession and making of the Constitution. Because Constitution was required. The state did not need 1939 Constitution at all. Constitution was required. Therefore, the letter of 1st of May 1951 saying that we have to constitute a constituent assembly for the state of Jammu and Kashmir. When, by that date, the Constitution of India had already been adopted. So consciously, on the one part, the federating state, on the other part, the Union of India agreed that the state of Jammu and Kashmir, perhaps, it looks like American Constitution. Your Lords would be well aware that there are two constitutions, one of the state, one is a federal constitution. Something on those lines, only for state of Jammu and Kashmir, not for any of the state in India. And I would go to it and say, once all states merged, they lost their personality. Even if tomorrow, I mean, going by this perspective, if tomorrow state list is not given to the other states, they can't say, sir, we agreed on this condition, because they merged. They don't exist, either under international law or under the domestic law. They don't exist. But our state was the only one which did not merge at all, so retained itself, a separate personality. Some part of the statehood was retained with it. Therefore, 370. Now, what does the 370 say? Look at, so far as the power to legislate is concerned, I say, I have a choice. You do that with my concurrence. Your parliament, you have list 1, maybe list 3, you have all the powers, all plenary powers. But you will not, it will be limited to. Your plenary powers, whether it is under list 1 or list 3, will be limited to by my concurrence. If I agree, yes, on a subject, please make the law for me, then only you will make the law for me. Not otherwise. Similarly, with regard to the constitutional provisions, I had my own constitution. I made provisions in my own constitution, whether it is High Court, whether it is Advocate General, whether it is the state legislature, whether it is the membership of the members. I made my own constitution. Now, when I make my own constitution, and on this, at the same time, I also agree through the mechanism of Article 370 that you apply A, B, C, D constitutional provisions to me. I have to take care of it, that they don't come into conflict with my constitution. I have to take care of that.
We'll continue tomorrow morning.